Welcome, everybody. Good afternoon. My name is Marna Maisonet. I'm the Chief Diversity Officer and a partner at Greenspoon Motor. We are very, very excited to have this seminar today. And we're very grateful that you can make it here. I know that you guys are busy, but we also are very thankful and grateful for our lovely panelists who are great friends of mine and have been very helpful in my own journey. I am located in Orlando, Florida, and I exclusively represent corporations in all employment matters. Today, I will be your moderator, and I would like to introduce the panel. The first speaker will be Mark Rabinowitz. Mark is a partner and a practice group leader in Greenspoon Motor and Family Law Practice Group. He focused his practice on complex marital and family law issues, including alimony, child custody, equitable distribution, prenuptial and post-nuptial marital agreements involving athletes, doctors, CEOs, and other people. Our second speaker is Patricia Gannon. She is a partner in Greenspoon Motor's Immigration and Naturalization Practice Group out of our New York office. She focuses her practice on business immigration and advises multinational corporations on various immigration issues, including employment verification, and develops various compliance strategies and programs. Patricia has represented Fortune 100 companies, artists, Olympic athletes, banking, telecommunications corporations, and an array of other international high-profile individuals. Our last speaker is a dear friend of mine who I owe a lot. Her name is Marla Neufeld. She's a partner with Greenspoon Motor Surrogacy and Assisted Reproductive Technologies Practice Group. She's out of our Fort Lauderdale office. And you know, the adage, necessity is the mother of invention goes here. She founded and represents parties working with a surrogate egg, sperm, embryo donors. She experienced her own infertility journey for many years and ultimately worked with a gestational surrogate family, surrogate to build her own family. Before we get started, I kind of want to go over some housekeeping matters. The first and foremost is that we ask you to please mute your microphone to avoid feedback and all the unpleasant surprises that can go with Zoom calls. If you have a question, please use at the bottom. On the tool, there's going to be a question and answer feature. We ask that you go ahead and put in your questions there that we will collect. We're going to speak for about 50 minutes to an hour, and then we have set aside 30 minutes for questions. So there'll be plenty of questions, time to address your questions. Now, we will be showing you guys some information, and please rest assured that everything that we talk here and everything that we say will be made available to you guys. So don't be afraid to, you don't have to take notes or anything because that material will be made available to you. And then I want to kind of tell you a little bit about me because it kind of falls into why we're doing this. You know, we all grow up with expectations when we're a kid. You know, you ask the kid, hey, what are you going to do when you grow up? We all say the same thing. Hey, you know, I'm going to marry somebody and I'm going to have kids and I'm going to have 2.5 kids. I'm going to do this and that. And we repeat that pattern when we go to college and when we graduate for college. And we learn that, you know, sometimes you have your future plan and your life plan mapped out. And I was one of those people until it wasn't. At 33 years old, I fell in love madly with a person who took my breath away and who I just couldn't live without. But I discovered, to my surprise, that my Prince Charming's name was Rebecca. And at that point, I had to make a choice. Do I follow my heart or do I follow my plan? I chose to follow my heart, and 20 years later, I don't regret it. But that choice brought about a lot of consequences and a lot of hurdles that most people will not have to face, okay? And that is important because it kind of changed who I was and how I view life. So while we all fall in love, we're not all treated equally, unfortunately. And that is something that in our community, we're very aware of. We have to do things like coming out to people that we know and love and people that we don't know and love. And in 2000, I too was forced to come out to my boss because the person that I loved was sick and I needed to get health care. At that point, I didn't know whether I would have a job at the end of the conversation. Because as you know, as of 2000, there weren't really any protections to same-sex persons, gay and lesbians or the transgender community. So I was at the mercy of my employer. Thankfully for me, the person was a lovely man who not only embraced me as an equal, but challenged me to change the world in which I lived in and allow me to use my voice and the voice of the law firm to engage in diversity. And that's why we're doing these seminars. So there's been a lot of progress, and especially in employment. It's taken, I had that conversation with him in 2004. And for a long time, you were at the mercy of where you live. If you lived in a good county and worked for a good law firm or any employment, you were lucky and that was great. But if you were unfortunate to work for somebody who didn't view your lifestyle in quotations right, then you could lose your job and that would just go, unpunished. It wasn't illegal. Well, we now know that the Supreme Court now in June, two months shy, in Boston versus Clay County, Georgia, ruled that Title VII, which is the federal anti-discrimination law, protects gays and transgenders for being fired. Now, that Title VII only applies to employers who have 15 or more employees. What does that mean is if you are lucky enough to work in a corporation that's 50 or more employees, then you would be covered by that statute. If you worked in a corporation with less than 15 employees then you are gonna be at the mercy of where you live, okay? So in the state of Florida, if you live in Osceola or, Orange County or Miami-Dade or Broward, you may have some protections. If you live in Duval County and other counties, you may not, which is completely unfair. And it requires people to kind of contact the legislature to address those issues, those inequalities. But there is progress, as I said, and we have to continue to voice and engage people because you got to win hearts one at a time. Now, part of the progress comes also, came to us when we wanted to get married, Rebecca and I, in 2011. We had to look for a place where it recognized the marriage. And then we had to figure out what did that mean? Would it be protected? Would it be considered legal? If one of those died, what would happen to the property? I had to go and talk to Mark Rabinowitz so he could advise me so we could figure out how to make it legal because it wasn't recognized everywhere. Now we, as I said, have come a long ways from that time. Now in 2015, as you know, the Supreme Court recognized the right for gay people to marry. And with marriage also comes gay divorce. So I am going to turn it over to Mark, who will give us the update on issues dealing with, divorce and marital issues dealing with for same-sex partners. Thank you.
Well, good afternoon, everyone. It certainly is a pleasure to be here. And I want each and every one of you to fasten your seatbelts as I try in 15 minutes to talk about 26 years of change in the area of family law and same-sex couples. What is necessary for everyone to understand is, first off, a lot of my presentation, or most of my presentation, is going to center on Florida law because that's where I practice. And every state has its own set of rules and regulations with respect to reproductive technology statutes, with respect to family law, with respect to paternity. And so, although I believe the concepts I'm going to talk about are generally true throughout the United States, the cases that we're going to discuss are specific to the state of Florida and the laws of the state of Florida. Could I ask to put up the first slide, please? What's important to understand is that in 1994, 26 years ago, Florida courts, and courts in other states as well, began the concept of talking about what is a parent. And when they talked about what is a parent, they talked about parentage as it concerns time sharing with the children. Florida became a very strict statute insofar as granting parental rights. And in Florida, although the legislature decided that there was a legislative right that grandparents had to have custody and time sharing with their children, the Florida courts struck those statutes down and ruled that only parents would have the right to have time sharing with their children. And even if litigants agreed to the fact that grandparents had contact rights, those contact rights were unenforceable. I can tell you that that is not true throughout the entire United States, that each state is somewhat different. But in Florida, grandparents had no time sharing rights. So conceptually, where do we go from there? We go to the Lamaritata case versus Lucas. And that's an early case in 2002. And in that case, Mr. Lucas donated his sperm to Miss Lamaritata. And along the way, Mr. Lucas decided that he wanted to have rights of contact or time sharing with the child born from the in vitro fertilization. And the Florida courts that decided that issue looked to our reproductive technology statute, and specifically looked to Florida Statute 742.14. And that statute, and if you think about it, you'll understand the logic 18 years ago in deciding that. It's the statute provided that a sperm donor would not have parental rights towards the child that was born as a result of the donation. And in fact, the statute itself provided that the biological material that was donated towards conception, the person that donated that material didn't have any rights to the child, with the exception of whether there was an agreement that they would become what's known as a commissioning couple. And the definition of a commissioning couple under the statute said, and this becomes important in the next 15 years, that the commissioning couple had to be a mother and a father. We move on down to the Wakeman versus Dixon case at 921 Southern 2nd, 669. And in that case, the child was conceived through artificial insemination, and there was actually a contract that was signed between the same-sex couple. And that contract provided that they would mutually raise the child. And in fact, they did mutually raise the child for about 3 years. At the end of the 3 years, they separated. Now, when you look at this, this was a case decided in the year 2006. And Florida had a specific statute that did not permit marriage between same-sex couples in the year 2006. So the court, interpreting the case law, looked at Taylor and said, wait a second, under Taylor versus Kennedy, a non-parent cannot have time-sharing rights even if they sign a contract. They looked at La Maritata and they said, even if you donate material towards the conception of a child, that is not enough unless you're a commissioning couple. And so the result of the Wakeman case was that despite the fact that they entered into a contract, and despite the fact that she had been involved, the same-sex couple had been involved in the raising of this child for a period of time, since there was no marriage, since there was no commissioning couple, the parent was not entitled to any contact rights, the non-biological parent, with the child. Then we had some other very interesting cases that were decided thereafter. We had a case called Budnick versus Silverman that's found at 805 Southern 2nd, 1112, and that will be up. And in that particular case, the parties entered into a contract where the father agreed and the mother agreed that the child that would be born as a result of regular sexual relations, not artificial insemination, but regular sexual relations, the father would have no contact rights with the child. And several years later, what happens? The mom sues the dad for child support and files a paternity action. And the dad says, wait a second, I'm a sperm donor. Under the sperm donor statute, I don't have any parental rights with the child, so a paternity action seeking support against me should not be upheld. What did the court find? The court found that, wait a second, the sperm donor statute falls under reproductive technology. This woman became impregnated through the regular, normal way of creating a child. And since there was not reproductive technology used, guess what? You're a dad, you fall under the paternity statute, and the mom can get child support from you. Then we go to the AAB versus BOC case. And as you're going through these cases, you're beginning to see we're running from 1994. Now we're in 2013. Now the issue regarding same-sex couples having the right to marry is being spread throughout the country. The case is going through the courts. Oberfeld is on its way up. Mores and values are changing. Our country is becoming more educated and less polarized to the issue of same-sex couples. So in the AAB case, the child was conceived to a same-sex couple using the sperm of the brother of one of the partners, but not through do-it-yourself methods, but not through a laboratory. And the case doesn't tell you how it was done, so I don't even want to guess how it was done. But it was done. And what this court then says is, wait a second, this was not done in the ordinary, customary way. It may not have been done, the conception may have not occurred through a laboratory, but it did occur under other than customary normal circumstances. And because of that, it did fall under the artificial insemination statute under 742, because it defined artificial insemination as procreation procedures which involve laboratory handling of human eggs, but it didn't require artificial insemination to be performed in a clinical setting. So you're left to your imagination. It wasn't done in a clinical setting, but it wasn't done the normal, customary way. And under those circumstances, it did fall under 742. And the oral agreement that the brother was only the sperm donor, and the brother, because of being the sperm donor under the statute, was then found not to have parental rights. Let's move to the next slide, please. The McGovern case is a case that just happened in June of this year. Factually, a fascinating set of circumstances where there were 4 children born to a same-sex couple. 2 of the children were born before the parties married. 2 of the children were born after the children were married. This came in the trial court in Orlando in front of one of the finest judges we have in Orlando, who was just recently reelected. And the finding that the trial judge made was the children that were born after the marriage was performed, they were legitimized by the marriage, and yes, both parents had parental rights of those children. But the 2 children born outside the marriage, he found were not legitimized under the then existing law. This went up in front of the 5th District Court of Appeals. The 5th District looked at this, and I'm sure they scratched their head and said, wait a second. We have a statute that says children born outside of marriage to a heterosexual couple and the couple then marries, those children that were born before the marriage are legitimized by the marriage and found to be children born as issue of the marriage. Why is it any different than in this case? And they then looked at the statute 742 and says, what is a reputed parent? A reputed parent, as defined under that statute, is a parent that agrees to take on all the parental responsibilities of a child, which Mrs. McGovern did do in this case, and who acts like a parent, raises the child, interacts with the children. And the 5th District overturned Judge Apt and said, no, because McGovern acted as a reputed parent, as that statute is defined, and because that she signed an agreement that she would have contact with the children, that Mrs. McGovern was a parent under the statute and entitled to time sharing and contact rights with the children. Can you turn to the next slide, please? Let's go to the next one. This, I think, for Florida is the most important case of all the cases we're going to talk about. And it is a fascinating case. In this particular case, there was a lesbian couple where one of the partners provided the egg that was inseminated and transferred into the other partner. The procedure was done in an IVF clinic. The two people decide to raise the child together. When the child was 4, the birth mother moved to an undisclosed location. Actually, the location was Australia, which interestingly enough has very difficult rules regarding permitting child contact. So she moved to Australia with the child, and she claimed the birth mother had no rights, because if you remember where we started back at La Maritata, where Mr. Lucas had given his sperm and then wanted to be a parent to that child, they looked at the statute and they said, well, wait a second, if you are a sperm donor, you're a non-parent. But the question here was, that in this particular case, the mom had, the mom who had donated the egg had said that it was her intent to be a parent to this child, to raise this child. And then they looked at the wording of commissioning couple. And if you remember at the beginning of this lecture, I said commissioning couple was defined as a mother and a father. And what the Florida Supreme Court did, would you flip to the next slide? What the Supreme Court did was it found that that statute that used the word mother and father was being used in an unconstitutional manner by excluding lesbian couples, and they found that in order to give life to the statute, that in this particular case, there was no question, but that both parties were commissioning couples, and that the application in the lower courts of this statute was unconstitutional, and that it denied the donating parent, the parent who donated her egg, both due process and equal protection. And since the biological mother always intended to parent the child, she couldn't be classified as a donor. And because she couldn't be classified as a donor, she was part of a commissioning couple. And the long and the short of all of these cases are, this is a confluence of different professions, of science, of law, of change in social mores, to be fair and just to everyone, to put everyone under the big tent. And the benefit is to children. Thank you.
Thank you, Mark. That was really great. And as he said, it's very interesting. If you're not from the state of Florida, obviously you have to look into your state, but thank you for that very interesting speech. Next, we're gonna have Patsy, because as you know, we all fall in love, and it's not like the old way where you just went to a bar. Now you can marry people from all over the world. And when you marry a non-United States citizen, then there's some different consequences when you wanna have kids outside of the United States. We use donor sperms or surrogates, there's different laws. So Patricia, I'm gonna pass that down to you, and thank you so much.
I forgot to unmute. I'm sorry. I'm still getting used to Zoom. And Mark, thank you so much. He's a very tough act to follow, I'm afraid. But I will say immigration is interesting in its own right. Just so you know, I've been practicing immigration for over 25 years and practiced 13 of those years with the federal government and with immigration. So I certainly have an understanding of both sides. We do a lot of business immigration here with GM, and we do a lot of naturalizations. And when Myrna gave me the opportunity to speak with you, for you guys on this, beautiful panel, I was like, wow, surrogacy with children born abroad is a niche within a niche, for sure. With that said, there are some issues that do face the LGBTQIA plus community. So I think that, on the first slide, you'll see that there's just a few things that you should know, that everyone, if they think in terms of a foreign national in the United States, if you really think about it, when people are in the United States as a foreign national, they're going to receive treatment much like anybody else based on who they are. It's not going to be any different, but it's going to be more because they are immigrants, I believe. And if they're here illegally and they're put into deportation, there's not going to be any accommodations. And in fact, this should be a no surprise, they are at greater risk. That community is in greater risk and how they're being housed, who's fighting for them, who's trying to get them rights in detention so that they are not even further ridiculed and abused. When people come into the United States and they marry in the United States, we're talking about in the United States, they file key documentation in order to eventually stay here legally, work here legally, and get their green card. And when they do so, sometimes they are marrying into cultures that don't really recognize anything other than someone who's heterosexual. So they do so, and they may never, ever, ever speak to their families again. And when you do get married and you file certain papers, you eventually will interview before an officer. And sometimes people don't know the father-in-law's name, the mother-in-law's name, the sister, because since they've met their partner, that person does not, that family does not acknowledge them. So there have been cases as well where people are just not, there, there's been cases as well where people are not getting their green cards granted because the officer does not believe that there is a bona fide or a truly real marriage. So that was one of the things I wanted to bring up as well as far as issues with the LGBTQIA+ community. There is just a lot of other issues that face that community, like other communities, but even more so. And as a side note as well, there is a lot of asylum cases that are being denied and are being denied as they do not fear that they have a fear of persecution per se when returning to some of these home countries. So now, and I know that I don't have tons of time and I'm trying to do this very fast because there are really a lot of issues that do face this community like every day. Like it's hard enough. I don't think people, I mean, I don't know to what degree everyone who is called in today understands, but immigration is very full of very different policies right now that are quickly changing every day. And a lot of them are not very pro immigrant or even pro business immigrant or even pro foreign national for people who are even legal in this country, much less for a community that within the LGBTQIA+ community. There is no um, there is no special accommodation in any way. So it becomes a little bit more difficult for them to get certain exemptions as well. Okay, next slide. Um, so these were just some of the, some of the things on this slide just basically, you know, talk about some of the things that are happening and how many of these of this foreign national group has been met with harassment, not being provided life-saving medication, and obviously for those who are in immigration, this is not new news. We have children being detained, for example, that aren't even being received proper care. But we do want to point that out and show it as a highlight of the precarious situation um, that this community finds himself in every single day that they come over our borders and into our country. And you know, we hope that in time this will be a more welcoming experience for all people. But for now, this is, there's been lawsuits and dismissed suits, and some of this, unfortunately, doesn't even make the national news anymore. I think we've become somewhat numb to it. Um, so we can go on to the second slide. Um, this is the last of the slides. I'm sorry about that. And, I was intensely listening to Mark because he was saying, look at how far we've come since I think you said the ABB decision, Mark. And, look at how far, people have become more educated, people have become more, less polarized, more advanced. And then I'm thinking, immigration, maybe not so much. I wouldn't say that. So immigration, so you were so like things are moving forward and marching forward in your field, and yet in immigration we find ourselves maybe not moving in ways that we find progressive, or forward. So immigration, and I think everyone knows this, but if you're born in the United States, we all know that the 14th Amendment says, good for you. you're a US citizen. Congratulations. And we know from immigration and naturalization that, hey, if you're, born abroad and your parents are US citizen, you're okay. And if you're like me and you're from Minnesota and you border Canada, sometimes people come from Canada and they're like, oh, you're all US citizens, and then their kids, when they grow up, try to have it, but they were never resided in the United States. And they're like, okay, so maybe you can't be a US citizen automatically and you have to find a certain route. So, and citizenship is old. It is our oldest law. And I just want you guys to know that when it comes to surrogacy and immigration, um, they do not look, even though really it's not really defined in parent law, they do not look at this in terms of parents. This is one of these areas that they look at it in terms of the gene, if you will, or the DNA of the child, so that they will determine if a child is born abroad through surrogacy as out of wedlock. And if you can just change the slide, that would be really good. And this slide is going to be available, and there is an organization called Immigration Equality, and I'm probably promoting them there. But here's the thing: if you go to the USCIS website, you're going to find a lot of charts in naturalization and citizenship, and you're going to find a lot of charts because citizenship can go up to your grandparents. So you're always going to find something that says this, right? So I want to make sure, I'm sorry, I have to hurry now. It says so. Um, the, so anyway, so I wanted to do this chart because this chart is very, very specific to what we're talking about. And Cavetti is just the latest of these. It's recently been, it's 60 days to take an appeal. The State Department agreed with the parents in this case, and then of course the State Department, federal court, they won under Judge Chang out of Maryland, who everyone in immigration loves because he argues with the travel ban all the time. And of course, everybody's taking an appeal on this. The State Department does not want to lose. If you look at this case, they had a child before, and the child was with one of the fathers who was born in Israel but came to the United States in 1982 and had stayed here until close to 2001. So any residency requirements was fine when they looked at the child, but they didn't even know it because when they submitted the papers, they didn't think about it, and the child was born in Canada, but the child got an automatic US passport. But when they had the second child, same way, they used the sperm of the other dad, and the dad, did not have those residency requirements. He was a U.S. citizen through naturalization, but he had no residency in the U.S. And that is what's happened. And they define it as born of the State Department. They take the INA because the 14th Amendment does not apply, and because it's a child born abroad, and they say it's born of the biological parent, and that's how they look at it. I know I have to go. Um, Look at the charts. How do you advise people? Have them born in the United States, of course, but that doesn't really solve the real issue that we're going through right now, where these people were discriminated against. It does violate equal protection, and there's truly no reason for it except for their interpretation of INA, because INA doesn't really define parent, except it only defines parent in terms of the child. So you can have deceased or adopted, but not in terms of citizenship this way. So I think it's a real stretch, and we hope that, when it goes up to the Supreme Court, that they're really going to look at this for citizenship. And the reason you don't see a lot of this on the national news is because I don't know why, because this is really quite outrageous. But you'll see the charts and you'll see why. And I'm sorry if I took too much time. Thank you very much.
Thank you, Patsy. I apologize for not giving you too much time because you're very great at what you do. You're very well recognized, and I think we can just go on and a whole hour on this. And so I apologize. But again, if you guys have any questions for hot seat, just let us write it down on the Q&A, and we have some questions lined up that we're gonna answer at the end. I want to introduce you to the next speaker, which is Marla. Marla is a dear friend of mine, and you know, the good news when you're gay is that you cannot get pregnant or get anybody else pregnant if you're in a same-sex relationship. But that's also the bad news. So you're not gonna have a one-night stand or oops moment. Not there's anything wrong with either of those two at all. It's just you're not gonna have that. So you're gonna have to go through this process. And for us, when we wanted to have the kid, we wanted to have a child. I consulted with Marla, both on a personal basis because we had a miscarriage, and second because you know things you have to go and see what the laws are so where you can appraise yourself and put everything together, because the last thing you want is if something happened to the biological mother, which would be Rebecca, that I don't have rights over my own children. So without further ado, let me introduce you to Marla.
Thank you so much, Myrna, and thank you for including me in this panel. Myrna, you know I adore you, and it was such a pleasure to have the opportunity to work with you and speak on other panels. And great idea to think outside the box to merge these really diverse practice groups, but interestingly enough, not on a day-to-day basis, but often I do get to work with the different colleagues at my firm for marital issues, immigration issues, and sometimes employment as well. So just a little brief moment about myself. My name is Marla Neufeld. I'm a partner at Greenspoon Martyr. I chair the reproductive practice group. And I actually worked with a surrogate myself to have my twin boys. And so that, my personal experience is what brought me into this practice area and to start doing this work at the firm. So we can move on with the slides. So, you know, surrogacy is obviously a huge opportunity for same-sex couples to have a child, many times biologically related to them. This is just a fun slide to show some different examples of some celebrities, famous celebrities that have worked with surrogates, but surrogacy is not just for the rich and famous. So many different types of people come to me to work with surrogates to build their family. And so this is one of my favorite slides. It's actually a merger of Myrna's beautiful babies and mine. So I call this, for me, the best before and after picture. And so just wanted to share our personal experience in third-party reproduction. Next slide, please. So just really briefly, I'll give a little overview on surrogacy. As we stated earlier, a lot of these topics are state-specific, not so much the immigration component, but for what I do, what Mark does, it's very state-focused. So I'm going to mostly focus on Florida law. But just generally speaking, there's two types of surrogacy. There's gestational surrogacy and traditional surrogacy. Gestational is the most common form of surrogacy where the surrogate has no genetic connection to the child. So there's a variety of ways you can create the embryo. It can be both intended parents, genetics, it can be donor sperm, donor egg, or in Florida, you can actually work with a completely donated embryo as well and still be protected with your rights. Traditional surrogacy is where the surrogate does have a genetic connection to the child. It's not illegal in Florida to work with a traditional surrogate. It's just very legally risky because she does have a window of time to change her mind and not basically terminate her rights to the child, risking the intended parent's parental rights. So we do have a statute in Florida regarding surrogacy. It's 742.15. Interestingly enough, our surrogacy statute right now is only for married couples with the genetics of at least one of the parents. That being said, any person can work with a surrogate in Florida legally. If it's a single person or an unmarried couple or using a donor embryo where they don't have at least the genetic connection of one parent, they just do it under a different statute. But at the end of the day, all types of people can legally work with a surrogate in Florida. No matter what type of person comes to me wanting to work with a surrogate, they do need an agreement in place. And any fertility clinic that's working with surrogacy will not allow the parties to proceed with any embryo transfer until there's an agreement signed by all the parties where everybody should have separate representation. So there'll be an attorney for the intended parents and a separate attorney typically paid for by the intended parents for the surrogate. The only legal requirement in Florida is that the surrogate be 18 years old. Typically, I mean, they're never that young, but really what goes into picking your surrogate are many, many best practices of what people look for, you know, stable living environment, uncomplicated prior deliveries, healthy lifestyle, things like that, that a doctor and a mental health professional typically will evaluate. So next slide, please. So as I said, every state does have different laws. Florida does have a medical need requirement. And I always chuckle to myself when I prepare an affidavit for same-sex couples, kind of what Myrna was touching on before. Obviously, there is a medical need for a same-sex couple, especially a male couple, to have to work with a surrogate. You know, medical science has only come so far. We have not been able to, you know, impregnate a man yet. So anyways, but you do have a medical need to work with a surrogate, and the fertility clinic is typically the professional that would sign off on that. Florida law does not get into too much of what the need requires beyond what's in the statute. So it's really for the risk of the intended mother, for the risk of the fetus, or if the couple can't physically gestate to term. So many times, same-sex male couples, I mean, that's what they would fall under, and same-sex female couples could be a variety of reasons why they need to work with a surrogate, or individuals as well. Next slide, please. So then our statute elaborates on what needs to go into the agreement. An important thing when picking your surrogate is making sure that everybody sees eye to eye with some of the big picture items, such as does the surrogate agree to terminate a pregnancy or reduce a pregnancy if it's something that the intended parents would want her to do. Ultimately, any decision regarding the medical intervention of the surrogate's pregnancy is a decision for the surrogate to make. So while a contract may have certain obligations and commitments a surrogate makes to the intended parents, for example, if she would abort the pregnancy if there was an abnormality, ultimately, if a surrogate ever changes her mind, a court would never force the surrogate to have or not have an abortion. So it's really important going back to the matching process to make sure parties see eye to eye with some of these big issues, how the pregnancy is going to be handled throughout the term. And these are all discussed at the beginning of the process and go into the agreement. Next slide, please. So as far as parental rights go, parties are very protected in Florida. Basically, in short, the intended parents assume rights to any child born, and the surrogate gives up any rights to the child born unless it ends up being her genetic child, or that kind of crazy scenario is if there's a clinic error, but that's a whole nother story that, typically don't have to worry about. But in Florida, parents can feel comfortable knowing that their legal rights are protected when working with a surrogate. Next slide, please. And in Florida, you can make certain payments to the surrogate that are classified as that relate to the pregnancy. Some states you cannot pay a surrogate anything that's beyond expenses that are paid out of her pocket. So again, that goes to that state by state determination of what's permitted, and even some states don't even allow surrogacy contracts as being enforceable, and it could be a crime in some states if you do compensate a surrogate. But in Florida, certain payments are made to the surrogate for what she's going through, what she's putting her body through, which is a big commitment for her. Next slide, please. Our statute does contemplate the court process to affirm the parental rights of the parents. Florida is a post-birth state, so basically once the baby's born, there are certain court proceedings that have to take place to place the intended parents on the birth certificate and make sure there's no reference to the carrier. Some states have pre-birth proceedings. Florida is a post-birth, and you have to file this timely and handle everything with the hospital in advance of the birth to make sure that the parents will be having all medical decisions. They take the baby home, they're banded as the parents, and will be placed on the birth certificate. Next slide, please. This is the statute, just for anyone's reference, for when an intended parent is single, or they're not married, or the genetics are not related to any of the parties, so donor embryo. You do it under what's called a pre-planned adoption statute. Next slide, please. This ties back to what Mark was talking about with all that fun case law. Florida does have a donor statute. So this sets out the legal rights of when somebody donates eggs, sperm, or embryos. And Mark, with your case, the AAB, I would argue to say that it was some form of turkey baster that was used. for methods of conception, and you'd be amazed at the creative things they sell for home inseminations. They've gotten very creative with that. But for a donation of gametes, it's important that a contract be in place to avoid some of those cases of the ambiguity, whether or not someone's a donor or not. So for any donation that's involving a fertility clinic, more times than not, they will require an agreement in place between the parties. Again, it's best to have separate representation for the intended parents and the person donating the egg, sperm, or embryos, so that the intent is very clear on what's being relinquished and what parental rights are being assumed. And Mark talked about the definition of commissioning couples. That's been broadened to not just include intended mother and father, although the language is still in our statute. So moving on to step-parent adoptions for when a same-sex, well, in relation to same-sex couple issues, a step-parent adoption is what we can use when the couple is married. A second-parent adoption is when the couple is not married. So if you can go to the next slide, please. So obviously we all know that as of 2015, same-sex marriage has been recognized in Florida. And it's a little, I think, offensive to even suggest to a married couple that they have to do a step-parent adoption once their child's born, being that we do have a marital presumption in Florida that any child born into a marriage is the child of the marriage. Any child born in Florida to a same-sex couple will both be on the birth certificate. A birth certificate is just a presumption of parentage. So it can be rebutted, basically. So it's still the best practice for any same-sex couple, married or not, to do some form of adoption proceeding after the baby's born to solidify the parental rights of both parties, because a court order is a higher degree of protection than a birth certificate. And it's not necessarily absolutely required. It's just more of like a belts and suspenders that is still deemed like a best practice to do. You know, a court order is something that you have recognized by full faith and credit. And although same-sex marriage is recognized in all states in the United States, that may not be the case for people who travel and live abroad, where same-sex marriage might not have the same protection. So it's really just that extra step that couples are still taking to protect their parental rights. This is not with surrogacy. This would be more seen with forms of insemination, IVF, among same-sex couples. So I'm not really going to get too much into this case. This is what Patsy spoke about with international, when parents from the United States have surrogacy, you know, children via surrogacy abroad, and all the inequalities that were occurring, treating these couples as out of wedlock. There has been some, you know, positive cases where they're, you know, overturning that denial of citizenship to the children. But most of the cases that I handle, I mean, the matters that I handle would be the flip of this. So this is where intended parents go abroad. I represent many parents coming to the United States to have their children, and then the complications that are occurring right now because of COVID with getting parents into the United States to get their children who will be US citizens, and then conversely, all the challenges right now of then getting the parents back home. So I'll skip this if we can just go to the next slide, please. Okay, so COVID's impacted us all in a bajillion different ways. In my little world of surrogacy, these are just some of the big things. I mean, at first, as we know, things just came to a halt. So fertility clinics for a while just like stopped everything. And that has picked up. I mean, right as of now, I'm really not seeing much delay on clinics. There are obviously social distancing and scheduling practices that are maybe delaying cycles, but not by much. Quarantine periods is like the biggest issue I see, especially like, for example, if there's an egg donor that was flying to New York to donate her eggs, whereas normally she could go up and back to Florida in a couple days. Now, if there was a quarantine period, the intended parents have to pay for 2 weeks of, or negotiate with who's going to pay for hotel for 2 extra weeks and living expenses or food per diems. So that adds just like a new element. And obviously intended parents and surrogates are concerned about being pregnant in the time of COVID. And, you know, with the surrogacy, you're trusting someone to carry your child and do as you would do. So it just adds to that same kind of element of trust who you're working with, and making sure that it's all discussed at the beginning. International travel is tough, and Patsy, I know you do this every day. You can stay with the other slide. I just keep it there. If you could go back. At first, I mean, people could not get into the United States, and I've had situations of intended parents unable to get into the United States for a good amount of time while the baby was actually born because of certain travel bans. So there's a lot of logistics that have to get worked out with international intended parents getting into the United States, coordinating it with consulates, getting additional documentation to prove the necessity for them to get here. And then once you deal with all the consulate approvals, just getting a flight booked and not canceled was complicated. So many times intended parents had to appoint powers of attorney and healthcare surrogates to who's going to care for the child if they can't get here in time. And that's been a big consideration that intended parents were having to make and still are making. The flip side of getting into the United States is leaving once they have the baby. And there's been some delays with all steps of getting documentation, birth certificates, passports is really complicated to get right now. There are certain life or death exceptions, and this kind of goes to the next slide, but there are a typical passport right now, the Department of State is saying can take anywhere between 5 and 6 months. So what intended parent can leave their home country, come here and stay here with a newborn for 5 months? They need to get home. So the Department of State, it's evolving. It actually recently just changed. There is a life or death exception to still get, if you get approved for it, to get an emergency passport issued. But essentially the intended parent has to have some kind of life or death emergency back in their home country relating to an immediate family member that has to be documented by a doctor, and the travel back home has to be within 3 days before you can even ask for that exception to get back home. So there's definitely more logistics to work out with getting parents in and out of the United States. I am being successful working with a team with immigration attorneys and other reproductive lawyers, and it's definitely it's teamwork to make the dream work, but we are being successful in getting intended parents here and getting them back home with their family, with their babies, to enjoy and move on from all of this. So there's other COVID implications, but that should be enough for the moment to talk about. If you could go to the next slide. We just spoke about this with the life or death passport. So we can go on. And this is just another implication. Many Social Security offices are closed right now, and because initially the Social Security card is not issued at the hospital because you don't want to link the surrogate to the baby's Social Security ID. Intended parents have to basically apply by mail, and it's a little complicated because you do have to send original documents in that some parents can't part with right away. So it's a matter of figuring out the best timing for when intended parents should make their Social Security application. This is not as pivotal as like getting a birth certificate and a passport, but intended parents certainly do want to make sure they get their Social Security cards in place for the child. Next slide, if there even is one, that might be the end. And that's it. I also want to mention, as going back to like my very first slide, you don't have to go to it, but I said that surrogacy is not just for the rich and famous. So many different types of people do work with surrogates. There are resources out there. For example, I am involved and do donate my time to an organization called Men Having Babies. They're an incredible resource of information. They do offer different tiered, I don't know if you classify it as like a grant or scholarship type opportunities that either offer discounted services for same-sex male couples having children, or even sometimes offering free services to them. And they do have, in better times, live conferences and things like that. So there are resources available for all sorts of people wanting to work with a surrogate. So thank you, and Q&A away.
Thank you, Marla. And for the people, don't worry about it. The association that Marla said, we will, our tech will be sending something to that effect. But we have some questions here, and I'm going to start with Mark. Mark, the first question is for you. Can you guys unmute yourself? Okay. Regardless of the biological parent, non-biological parent, if the parent in custody dies with no living will, trust, guardian, custody document, what will happen with those innocent kids who could claim custody?
The question's a little unclear to me, but let me try to do the best I can with it. I'm assuming that in the question that there's been no determination of that both adults in the same sex relationship are parents. Only one person has been declared the parent in the question. That being the case, I would believe probably there would have to be a guardianship proceeding brought for a determination by the court as to who will be the guardian over the person and property of the minor. This is similar when both parents are killed in a common disaster. The way the question is set up, it appears to me that there's only been one parent who's been determined to be the parent of the child. I think that's the best I can do with the question as it's written.
Okay, so essentially the fact pattern is going to affect that, and you still utilize the child. You still have to go through whatever the statutes are and determine who would have rights to that child, whether they're parents or whatever, and then kind of duke it out from there. So that the important impetus of this question is, don't leave it for then when you're dead, because when you're dead, you cannot help out. You have children, you got to speak for them now. So if you're a parent and you don't have a will, get it. And I should do that myself now that I'm making this advice. Okay.
Sorry.
Well, let me just add one thing to that. When you're writing that will, it's important to determine who will be the best person over both the property and the guardianship over the person of the child. It may not be the same person. There may be separate people. You may have somebody who's a great nurturer, but perhaps not great with finances. So both of those considerations need to be thought out and put within the will.
Great. Thanks, Mark. And just so you guys know, I'm going to plug in Greenspan Water because we have great trust and estate attorneys that deal specifically with same-sex partners and unique relationships. Okay, let me go to the next question. It's for Patsy.
I may have answered it. I may have answered it already privately. It was from Monica, I think.
Okay, but since it may touch on other people.
Oh, yeah, good thinking.
Hold on a second. Okay, the question is, if the birth mother is a non-resident, but the biological father is a United States citizen, could you claim that the newborn could be a United States citizen? Is this something that you might consider when you sign a contract for surrogacy?
Well, definitely any contract has nothing to do with naturalization. They would just throw that out. So basically it comes down to when was the biological father, who let's assume for this purposes is going to be the parent or mother, when they became a U.S. citizen, and when did they live in the United States, and how long did they reside in the United States prior to the birth of the child. So those, it's a very fact specific. That's why you have all those little charts, because every little chart means something. When they were born, when did it happen, when did this? And if you go to USCIS website, they have a lot of charts too. It is a chart world. Because you have to remember, a lot of people go, and maybe I shouldn't even say anything, but a lot of people come to the United States, and this has been always, and they may have their kids here, and then they may leave again. So they may not even reside here ever. And then when they do have kids, they're like, hey, can I do this? And we have to look at those residency requirements.
Okay, thank you so much. Marla, this question is for you. It's a question regarding termination and surrogate. What is the possible latest week of gestation that surrogates can choose to terminate?
So that's a state by state determination of what is viability. So that's nothing to do with what the contract says between the parties. It's whatever applicable law would determine when a party can, have an abortion. And there's different exceptions if there's a risk to the mother and things like that. So, back to that point, the parties can say whatever they want in the contract, whether the surrogate will respect the wishes of the intended parents. Should the surrogate decide to not abort the pregnancy and still have the child, per Florida law, the intended parents still assume rights to that child. So you're, assuming parental rights, the statute's basically regardless of any impairment to the child. So it's super important that this discussion happen at the beginning of the process, when you're picking your surrogate, that a pro-choice intended parent is not matched with a pro-life surrogate and vice versa, and that it's evaluated prior to getting anybody pregnant.
So actually that's interesting because I just binge watched Little Fires.
Oh yeah.
And there's an issue of that. And I thought, wow, what a mess. Because I don't know if they don't explain it, but it seemed like she is the mother because they had a turkey baster thing.
Well, just to go, the what I just mentioned about the intended parents assuming rights, that's a gestational surrogacy arrangement. So in Little Fires, where it's her egg, that would have been the traditional, which is a whole nother set of laws.
Yeah, so that's interesting. Okay, we have another question. If the surrogate is asked to terminate, does not, as a gestational carrier with no genetic link to the child, is she required to adopt that child?
I think that's what I just addressed. That basically,
okay.
Yeah, the intended parents still assume rights to the child regardless of any impairment. So if the surrogate refuses to abort, and there's an abnormality, it's still the intended parent's child.
Okay. Another question is, what would you suggest for U.S. citizen couple who wants to sign a contract abroad, where to sign the contract, what the contract should say about governing law?
So I can't advise on any matter if the surrogate is not delivering. I mean, really, my jurisdiction is Florida, but if the surrogate is going to be delivering in another country, intended parents will have to consult with a reproductive attorney in the other country to determine if it's even legal and what the contract can say. Because unless the surrogate's delivering in the United States, and for me to assist, it's important for the surrogate to be here legally, so you don't have any risk of her having to leave the country and deliver in the other state. So long story short, if the surrogate's not legally here in the United States and will be delivering abroad, they need to consult with an attorney in the other country.
Yeah, and as Mark will attest, when there's disputes issued between international couples, there's also a treaty that applies. So you really, really need to get somebody involved in that. Okay, I have another question here. When is Florida the proper venue for a surrogacy contract if the surrogacy resides here, the state where the surrogate, well, okay, these are the things. When is it?
What allows you to use Florida law for a surrogacy agreement?
Well, no, let me read it. I'm sorry. I'm just, the thing keeps adding more questions, so I'm trying to, okay. When is Florida the proper venue for a surrogacy contract? If the surrogate resides here, the state where the surrogate gives birth, or where the intended parents live. I guess that the question is which form applies depending on, if anything, depending on those factors.
Jurisdiction in Florida to use the agreement. Good question. So Florida surrogacy statute does not define what allows the use of Florida law. My general rule of thumb is if the birth is occurring here, that we can use Florida law because it's Florida Vital Records ultimately issuing the birth certificate. There are some other scenarios that would allow the use of Florida law for the agreement, but if the surrogate's giving birth in another state, you do have to consult with an attorney in the other state to determine what the parentage proceedings would be like there. Some states do have within their statute setting out exactly what allows the use of their state law. For example, California provides different triggering events that allow California law. We don't have that. So I like to, the general rule of thumb, as I said, is the birth occurring here. But it's really a case-by-case scenario. That's my general rule of thumb.
Okay. I think those are the questions that we have already, and some of them we have answered. If we don't have any more questions, I think we have come to the end. I want to thank everybody for attending this. We certainly had a lot of fun, and we're very grateful for this panel, and we're very grateful for your attendance. As I said, everything that you saw here will be provided to you. If we have your email, we'll be sending it. We'll also be providing copies of the video, and they'll be available at the, wait a second, I'm sorry. Oh, thank you. We'll be able to provide that, and we hope to continue doing this. So spread the word, because a lot of people can still get the information even though we're not going to be live. So thank you so much, and everybody have a good day. And thank you, Mark, Patsy, and Marla, and our GM team that made us look so efficient and so great here. Thank you so much.
Thank you. Thank you for inviting me.
Also, guys, if you couldn't think of a question or wanted to ask a question, please send it to us, to the event people, and they will pass it along. And if we can answer it, we will answer it. Okay? All right. Thank you, everybody.
Thanks again.
Thank you. Bye-bye.
Bye.